Advisory Committee to order. It is 10:09 a.m. on the 22nd of September 2025. We'll do roll call.
James Nance.
Here.
John Bear Abear.
Here.
James Sutton Page.
Here.
Presiding Officer Frank Riley.
Present.
We have a quorum.
Great. Okay, that brings us then to, I guess, Harmon, do you want to welcome our new board members, John Abear, and would you like to say a few words, John? Bear, welcome.
Well, that's always a loaded question because I'm an auctioneer. I'm not exactly sure what a few words means, but certainly just want to say thank you. Bear is the name that I go by. So if you call and ask for John, I'd probably hang up on you. So just thanks everybody, and I'm looking forward to what we do together. I'm also the presiding officer for the advisory board for auctioneers. So just to understand, just to kind of let everybody know, transparency kind of a deal. So good morning, everybody. Good Texas morning to you from Pasadena, and I'm looking forward to the process.
Welcome.
Good morning, Bear. I'm happy to meet you. I hope to meet you face to face sometime. I like that hat.
Thank you, sir. I wear it every day. Well, not this one, but a hat.
We're also joined by Mr. Sutton Page, and welcome.
Thank you, and good to see everybody and meet everybody on Zoom. Just a little bit about me. I'm a cotton, wheat, sesame farmer. We farm southeast of Stanford, Texas, just north of Abilene, 40 some odd miles, and all dry land. And also a pilot. I've flown our weather mod program here in Stanford. I guess back when it started, 2015, 16, 17, and so some good working knowledge of how all that works. And someone mentioned Craig Funky a while ago. I'm originally from El Dorado, Texas, south of San Angelo, and knew Craig. And actually, before we moved to Stanford, I was in conversations with him about flying the program in San Angelo, but ended up moving. But anyway, that's really
Welcome aboard, and we're glad to have you all. It's been a little while since we've last met, and so there are some minutes that I don't know, Pat and I can remember that far back, but minutes from the meeting of August 21st, 2023. We had a chance to review those. Anyone have any questions?
None here.
Well, I would take a motion to accept the minutes if anyone wants to do that.
So moved.
Heard it. So moved in a second. All right. All those in favor?
I
How
can do
should
a
we
roll
do
call,
this?
sir. I can do a
Yeah,
roll
Harmon,
call.
that'd be great. Thank you.
James Nance.
I move to approve.
And how do you vote? Aye?
Aye.
Yes, sir. John Bear Abear.
Aye.
James Sutton Page. And Presiding Officer Frank Riley.
Aye.
Motion passes.
All right, great. Brings us to item E, public comment. We didn't have anyone that
Frank,
contacted us
can I
ahead of
stop
time?
you real quick?
Yes, ma'am.
Could we go ahead and do item C for the open government training before we get started on
Of course. Yes, I jumped right
Awesome.
over that. Of course. So we've got our Assistant General Counsel, Stephen Leary, who is with us. And Mr. Leary, welcome.
Good morning.
Thank you. He's going to provide us some open government training. that is
Yes, sir.
required of all advisory boards. And so I'll turn it over to you, sir.
All right, thank you very much. Yes, we give this training to anytime we have new board members, and also we give it once a year if we haven't already as a refresher. I'm Stephen Leary, Assistant General Counsel from the Office of General Counsel, and I'm going to be talking to you today about some open government statutes and how they pertain to how these advisory boards operate. I'll go ahead and share some slides on my screen. And, Carmen, please let me know if you can see the slides.
It pulled up nicely, Stephen.
Okay, very, very good. All right, so the three main open government statutes that affect our advisory boards are the Open Meetings Act, which is Chapter 551 of the Government Code, the Administrative Procedure Act, which is Chapter 2001 of the Government Code, and the Public Information Act, which is also referred to as Open Records Act. That's in Chapter 552 of the Government Code. We'll start with the Open Meetings Act. That's probably the main one that can cause some issues or that you'd want to be aware of. The purpose of the Open Meetings Act, and this is really the purpose of all three of these statutes, is to ensure an open and transparent government. The Open Meeting Act requires meetings of government bodies to be open to the public with a few exceptions. And it requires public notice of the time, place, and subject matter of the meeting to let people know what's going to be discussed in the meeting. And we do that through the agenda that we post. The provisions of the act are mandatory and are supposed to be construed liberally in favor of open government. One of the main concepts under the Open Meetings Act is a quorum. A quorum is the majority of the members of the advisory board as fixed by statute or rule. The quorum has to be present in order for the board to take official action. So if you're going to vote on an item, you have to have a quorum present. You can meet with less than a quorum, but you can't take official action without a quorum present. You can't engage in deliberations without a quorum present. When we get into deliberation, that's another key concept that we want to touch on. So what constitutes deliberations under the Open Meetings Act is a verbal or written exchange among a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. A meeting under the Open Meeting Act, and this is key because it's against the law to meet without complying with the Open Meetings Act. It's against the law to engage in deliberations, a quorum, without following these procedures for a meeting under the Open Meetings Act. So we have to know what constitutes a meeting. And the important point here is that what constitutes a meeting is pretty broad. It doesn't necessarily have to be a traditional meeting. A meeting occurs anytime a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or anytime the body takes formal action. We'll touch on the notice requirements under the Open Meetings Act. So the act requires advance notice of the date, time, place, and subject of each meeting held. We provide this in the form of an agenda, which we publish on the TDLR website. We also post what the Secretary of State put in the Texas Register. The agenda has to be up at least 7 days before the meeting to comply with the act. And when we're in the open meeting, the board or committee is prohibited from engaging in discussions about subjects that aren't posted on the agenda. So you're confined to what's on the agenda when you're in the open meeting. During one of these meetings, if you start to stray off topic, you start deliberating something that's not on the agenda, I will probably jump in and tell you, hey, that's not on the agenda. We need to discuss that at a later meeting. We do that to make sure that the board complies with the Open Meetings Act. That happens from time to time. Now, what about social functions, conventions, or workshops? Well, keeping in mind that a meeting occurs whenever a quorum of a governmental body engages in discussion about an issue under the governmental body's jurisdiction, can you ever meet in an informal setting without violating the Open Meeting Act? So can you all just get together at someone's house? Can you get together socially? You can get together. Okay, so the answer is yes. You're free to engage in conversations that are incidental to that event. You're free to get together. But if you're going to have a quorum of members and you're going to be talking about official business, then you can't do that without complying with the Open Meeting Act. So you can't get together and talk about whether or not we should approve of whether a modification application, whether or not we should do something with the rulemaking, any of those types of things. We need to comply with the Open Meetings Act if there's a quorum of you involved in that discussion. So there's some key points to remember. You always want to be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. Do not engage in substantive conversations relating to board or committee business or policy when a quorum is involved and you're outside of the officially noticed public meeting. And beware of the walking quorum. And so we'll talk a little bit about what a walking quorum is under the Open Meetings Act. A walking quorum is the concept that when you start out with fewer than a quorum of members engaging in discussion, but then other members get drawn into the discussion at a later time, and when all of those members together would have constituted a quorum, that can constitute an improper meeting under the Open Meeting Act. So, one of the things we're going to talk about today is possibly appointing a work group to look into some possible rulemaking. And it's fine for a work group that's less than a quorum of members to get together and meet. But if you have a discussion with a less than a quorum, and then one of you emails or calls someone else on the board, and now you have a quorum of members that have engaged in the discussion of the issue, that's what's called a walking quorum. And that violates the Open Meeting Act. So there's an example here on the slide. So you have a 5-member advisory board. I think that's what we have here is 5 members. So you have 2 members who are engaging in phone calls or emails on their thoughts about an upcoming rule change, exchanging research that they have individually performed regarding the issue. And that's fine. We want smaller than a quorum to work on work groups and things like that. But then one of the board members subsequently forwards that email exchange to another member. Well, now you have a total of 3 members who have engaged in this discussion outside of the open meeting, and that's a walking quorum, and that would violate the Open Meeting Act. So walking quorums, that can occur during a conference call, video conferences, hallway discussions, even through email, text message, or new technologies. So you have to be aware of that when it comes to social media and that sort of thing. Sharing information on social media, sometimes that could run afoul of the walking quorum. So I'll post something on Facebook about weather mod, and then you got 3 of you chiming in on that same post. That's another example of something that might violate or might constitute a walking quorum. So some precautions to avoid a walking quorum. You should not meet in small groups to discuss committee business or board business and then communicate those discussions to other members. Now, the way around that is if we break into a work group and we're going to study an issue and look into it, you're not going to want to discuss that information with people outside that work group until we get into the next open meeting. And then you'll have a work group report. We'll report back what the work group discussed and everyone can discuss it. So if you want to meet and discuss business outside of the open meeting in less than a quorum, that's fine, but you can't bring in other people, other board members into the conversation outside of the posted open meeting. There's also a concept called polling, and that can violate the voting requirements of the Open Meeting Act. It's a similar concept. So if you ask the board members how they're going to vote before we get into the actual meeting, that's against the Open Meeting Act also. You can't do that. You can't say, hey, I want to propose this at the open meeting. How would you vote on this? You call up everybody and ask them how they're going to vote ahead of time. The government frowns on that because it's against the law. It's called polling. It violates the requirement that the deliberation and the vote actually occur during the open meeting. So next slide. This is about the end of the Open Meetings Act. So during the open meeting, you want to limit your conversation to what's on the agenda. Now, during the public comment portion of the open meeting, the public isn't under these same restrictions. They can come in and talk about whatever they want to talk about that's germane to what this board does. But if you're going to engage with the public commenter, so someone comes in here and they comment about something and you want to respond to them, we have to be cautious because what that commenter is talking about might not be something that's posted as an agenda item for the open meeting. So for that reason, generally when there's public comment, we recommend that you simply acknowledge their comment. If it's a topic that's worthy of discussion, we can consider it at a later board meeting, but you don't want to get into a back and forth with public commenters during the open meeting because the topics that they're coming to talk about might not be posted as agenda items. To avoid violating the act on the basis of insufficient notice, you want to limit your, it's the same theme really. You want to limit your discussion to what's on the agenda. Don't allow discussions to wander off the agenda, and don't respond to issues that come up during public comment that aren't on the agenda. Now, what happens if there is a violation of the Open Meeting Act? Well, there's a couple of things that can happen. As far as civil remedies, the Act provides that someone who claims that the Open Meeting Act has been violated, they can file a lawsuit and a court can invalidate any action that the board took that violated the Open Meeting Act. So if you took some kind of a vote, but you didn't have a quorum, or you considered a matter that wasn't on the agenda, it's a basis for a court to invalidate the action the board took. There's also criminal penalties for violating the Open Meeting Act. That doesn't come up very often. That'll most likely be for pretty egregious violations of the Open Meeting Act, but that is a possibility. We have to warn you. There's a possibility of 6 months in jail or $100 to $500 fine. And that's about it. That's about it for Open Meeting Act. There's some resources here in case anyone's interested. Or you can always reach out to me, Office of General Counsel. If you have questions about whether or not something's going to violate the Open Meeting, just reach out to me, and we'll set you straight. We're here to advise you. That's the handbook and guidance from the Attorney General's office. I want to touch on the Administrative Procedure Act. It's also called the APA. The APA is it sets procedures for government bodies in a couple of different ways. So there's the hearing provisions of the APA that deal with how we conduct adjudicative hearings. If we were going to take disciplinary action against a licensee, for instance, or if someone wanted a hearing on whether or not their license was approved, not this kind of hearing procedure, but more formalized licensing hearing. The APA touches on that. APA also governs rulemaking by a governmental agency. And that's mostly what I'm going to talk to you about, because that's the part of the APA that really affects advisory board operations. So the APA establishes uniform procedures and provides for public participation and transparency during the rulemaking process. Now, what constitutes a rule? This comes up because if a state agency does something, we put something on the website, put some guidance, we get some instructions to how people are supposed to do things. If a court later finds that that really constituted a rule and it should have gone through the formal rulemaking process, that violation of the APA could be a basis to strike down what the government body is doing. So in general counsel, we're cautious about this. So what actually constitutes a rule that would require rulemaking under APA is a statement of general applicability that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes a statement only regarding the internal management or organization of a state agency and not affecting private rights or procedures. The rule includes a new rule, an amendment to an existing rule, or the repeal of an existing rule. Next slide. So how do we engage in rulemaking? I mean, there's a process we go through to engage in rulemaking, but what leads us there? Well, there's a number of reasons why we'll do that. One that we're going to touch on today is legislative changes. So there are bills that get passed that affect either our program statute or our other statutes affecting our agency operations. And sometimes that requires us to engage in rulemaking to update the rules or to comply with statutes. The advisory boards are also common source of rulemaking. So you have expertise in this area, interest in the area. Quite often, you'll come up with ideas of things that we need to change that'll improve things. And so you're one source of ideas for rulemaking. TDR staff, sometimes the staff within TDR will have some concern and they'll suggest a rulemaking. There's a 4-year rule review process, which we're currently in for weather modification. What that is the APA requires every 4 years that we take a hard look at our current rules and consider whether or not they still need to exist, or whether we should repeal or modify those rules. And then the agency formally readopts every rule every 4 years. And that's just to make sure the rules don't get stale. There aren't things in there that don't keep up with the current times. There's also something called a rule petition, and that's a pretty rare procedure, but that allows an interested person or organization to petition us to engage in rulemaking. And if it meets the requirements of the APA, then we have to take action on that rule petition. So it doesn't make us engage in rulemaking. It makes us consider whether or not we're going to. And if we're not going to, we want to deny the rule petition, then we respond in writing with formally with the reasons why we're not going to engage in rulemaking. That slide touches on that. An interested person who can file a rule petition, you have to be a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, so like a groundwater district, something like that. They could file a rule petition if they wanted to. Public or private organization that's not a state agency but is located in Texas. Those are all folks who can file a rule petition. This is sort of a flow chart, and I don't want to bore you with detail. It gets kind of detailed, but this kind of takes you from the start to the finish of what happens during a rulemaking process. So you start out with the idea for the rule, and then there's some internal review and analysis that we look into whether or not we should do this, and how it's going to affect us. There's a mandatory review by the governor's office. So if we are going to engage in rulemaking, there's a memo that goes to the governor's staff, and he reviews it, and he'll greenlight, or his staff will greenlight it to be published to go forward with the rulemaking. There's usually a first advisory board meeting. Now, it's not necessarily first. There could be an advisory board meeting before that, but that's the meeting where we're going to formally propose the rule. The board takes a vote to propose it in the register. So the next step is we propose it in the register. There's something called a plain talk summary. You don't need to worry about that. Just a little summary of what the rule does to make it simple so people understand without having to dig through the rules. Once the rules go up in the Texas Register, there's a public comment period for 30 days. And people can write in with their comments about the rule. And then usually there'll be a second advisory board meeting after that to consider what comments came in to decide whether or not we should make changes to what we were originally proposing based on those comments. And then if the board after that votes to formally adopt the rule, then that gets put on a commission meeting agenda. And then the big commission, the commissioners vote on whether or not to adopt the rule. And then if it does get adopted, there's another notice that goes in this Texas Register called an adoption notice, and it'll state the effective date of the rules. So it's very complex, but there's a process. Just understand there's a process we go through for rulemaking. It takes some time. I already kind of touched on the 4-year rule review process. That's what we are in that right now for weather mod. There's been a notice of intent to review that's been published in the Texas Register. And we only got one comment on that. So we do that every 4 years. We go through a rule review, and if some good comments come in that we want to talk about, we'll talk about them. We'll consider them. We take that feedback seriously, and then we re-adopt the rule. If we want to, instead of re-adopting the rule, we want to amend it or repeal it, we can't do that during the rule review process because that requires separately publishing that we're going to want to amend or repeal the rule. So we'll take that into advisement, then we'll do that through a separate rulemaking process. Rulemaking resources, there's some resources here, citations to the various statutes. There's a handbook from the Attorney General Office. I'll move us along into the Public Information Act. This one will be shorter compared to the other two. Public Information Act is also referred to as the Open Records Act, and it enables the public to request information or request documents and records from a government body. Again, it's intended for public transparency. It's intended to provide information about government affairs and the acts of public officials and employees. There's a presumption under the PIA that every document is public record available to the public, and there's some exceptions that are in that act for certain things that we don't have to release. It's important to understand that the documents that can constitute an open record that we would have to release, it's not just formal types of documents. It can include your emails, your text messages, and so forth. And again, the act states that the legislature intended for it to be broadly construed in favor of granting requests. So if we don't want to release something, the burden's really on our agency to establish that there's a basis, justification to not release something. There's a little overview of the process. Understand this is a whole process. There are people who do just this, but just for our general purposes, the request comes in, and we have on our website a form to fill out to request information. If you get anything that looks like an open records request, whether someone emails you and requests documents, or someone says they want to request open records, refer them to the open records portal. And then if you get an email or any kind of written request for open records, forward that to the General Counsel Open Records team. It's important that we respond promptly to these things because there's a deadline for us to respond. If there's something in those records they're asking for that we're not supposed to release, we have a deadline to claim that exception. 10 business days generally from the day we get an open record request for us to respond why we're not going to release something. So because that's time sensitive, it's important if you get an open record request, forward it to us right away. Here's just an overview of some common exceptions of things that we don't release. Some personal information like dates of birth, driver's license information, license plates, VIN records, credit card numbers, some medical information. Generally, we don't release people's personal email addresses. We do release business or official email addresses from government bodies. There's a process if we think that we don't have to release something. We request a ruling from the Office of the Attorney General, and there's a whole process after that to challenge the ruling. So our open records attorneys deal with that, but just understand there is a process. This is slides just saying the same thing I just said, is that if you get a request, you need to forward it along right away because we don't want to miss that deadline and then be in a bad situation. Here's some links, information about open records. I'm open for any questions. Any questions about the government, open government training? This concludes my presentation.
I don't have any questions, but it's a great presentation.
Thank you.
Have you forwarded that PowerPoint to the board members, or could you?
We could. I don't know if it's in your written material. I think there's some other stuff in your written materials, but Carmen, could you forward that to them?
Yes, I can do that.
All right. Thank you very much.
All right. Back in the regular order of business. We didn't receive any public comments for today's meeting, so we'll move past item E and move us to item number 10. Field meteorologist reports on ongoing weather modification activities in 24 and 25. And why don't we start just alphabetically? Bria DeCaro. If I can pronounce that correctly.
Yes. Hi, members of the board. My name is Bria DeCarlo. I'm a meteorologist here in South Texas. I also run the Rolling Plains program based out of Stanford as well. But I'm just going to start with the South Texas program for now. We continue to work with the Evergreen Water District and as well as the Edwards Aquifer Authority. We continue also to have aircraft stationed in Uvalde and in Kennedy, which is in Karnes County. And last year in 2024, it was our 26th season. conducting cloud seeding operations across South Texas. And that started April 1st and concluded on October 31st. So last year was pretty average in terms of operations. We had 66 flights and about 114 flight hours. Archie Ruiz, based out of Texas Tech University, he conducts our analysis at the end of every season, and he evaluated 122 seeded clouds over 38 days. And the evaluation found an increase of about 400,000 acre feet of water production just over the South Texas Weather Modification Association target area. So far for this year, we started on March 1st, a little bit earlier than last year. And to date, we've had 29 flights and 40 flight hours. And that number is a little bit low because since the flooding occurred back on July 4th, we continue to suspend operations just out of respect for that. And our last operational day was on July 2nd in Karnes County. So we continue to be suspended for that. Moving on to the Rolling Plains program. Last year, we started on April 1st and we concluded on August 31st. We have a pilot stationed in Stamford, Texas. And then we had a pretty busy season. We had 47 flights and 56 flight hours. And an analysis just showed an average of about 530,000 acre feet of water production for that region. Back in 2024, we included the county of Borden County in addition to the target area. So yeah, they just wanted to be included in the weather mod activities. And then so far this year, we've had 25 flights in the Rolling Plains and about 29 flight hours. So yeah, that's about all that I have to report.
Thank you. Bria, I just have one quick question, and that is the conspiracy theorists out there occasionally will put things out on social media, but you noted that you stopped activities on July 2nd, and none of your activities in the South Texas project, or none of those are in the Guadalupe watershed, at least the upper part of that, correct? I mean, so that it really couldn't have had any effect, even if you've been.
Correct.
Okay. Thank you.
Can I ask a question?
You bet.
I'm just curious on the South Texas deal. I was born and raised in Corpus, and I know down there they're having a whole lot of issues right now with water shortages and stuff. Has anything been done down to that area, or do y'all have any oversight, in how that is coming along? I mean, their lakes are pretty much empty, and they're fighting over a desal deal now. So I was just curious.
Yeah, so we don't operate in, I think it's Nueces County or Live Oak. Our cutoff is pretty much Atascosa, McMullen, and Karnes County. If they do want to explore like any of their water districts or anything, want to explore weather modification and have us help them out with their water and whatnot, we would be more than willing to.
Well, that's
Yeah.
good. I know everybody thinks they're always going to get a hurricane, so they don't worry. They don't worry about filling the lake.
Yeah, one of our suspension criteria is to suspend operations whenever we do have tropical systems, tropical depressions, hurricanes and whatnot coming through, because the seeding effects on it at that point, it's already an efficient rainmaker. We're trying to target sick clouds. So yeah, but yeah, they've been pretty dry this year in terms of tropical storms.
Okay. All right. Thanks.
So, Mr. Chairman, I have a question.
I have
for
a
Ms.
question
Bria.
for Brett.
Go
Mr.
right ahead.
Chairman,
Yes, sir. Go ahead.
so Miss Bria, what is we have cattle in DeWitt County. So what is the process? How does someone get in touch if a county like to discuss being involved in the program? What's just the main channel of contact?
I think if you want to go at a county level, maybe getting in contact with your judge in whatever water district is within that area. And then you can reach out to, I'm employed by Rainmaker now, Technology
Okay.
Corporation. So reaching out to them, we're contracted out through the Edwards Aquifer Authority and the Evergreen Water Districts, just pretty much like our local water districts and county levels. Because I know
Okay.
McMullen and Karnes County, they're on an individual like county basis. So we have members on the board. I know one's like a judge and whatnot. So yeah, if you could reach out to me or your local judge or water
Okay.
district and
So
yeah.
without clogging down the meeting, someone could reach out to you for further, more specific direction.
Yes, sir.
Thank you very much.
And I have a question for Bria.
Go ahead.
Yes, I'm here.
Bria, one of the statistics is very valuable to us as we defend what we're doing is the percentage of improvement that the seeding does. Does that make sense?
Yes, you want to know a percentage?
Yeah.
Yes. So last year the evaluation found a 6.1% increase.
Okay.
But that equated to about a 400,000 acre feet of water production.
Okay. We understand percentages better than we do acre feet.
Okay, I'll remember that for next time.
Thank you.
Yes, sir.
Thank you, Pat. Anybody else? All right. And well, thank you very much, Bria. Corey Clay.
All right, can you guys still see and hear me all right?
Yes.
Yes, sir.
All right. Okay, I'm Corey Clay. I'm the meteorologist for Panhandle Groundwater Conservation District. Our season goes from April 1st through September 30th, so we're wrapping up here. I think we've got another 8 days or so. For 2024, we had a total of 60 flights. 38 of those were seeding flights. The other 22 remaining flights are recon flights. 32 seeding days, 100 flight hours, and we did use a total of 724 BIPs along with 46 hydros. That was a very active year, one of the busiest years we've had in about 15 years or so. So far this year, we've had 46 flights, 33 of those were seeding flights, 13 recon flights, 26 seeding days, total of 71 flight hours, about 500 BIPs, and about 40 hydros have been used. Like Bria's programs in Texas, or all the programs in Texas, we were also suspended, but we were only suspended for about 3 weeks. But during those 3 weeks, it was pretty active, so we would have been able to seed quite a few more days. But unfortunately, we were suspended during that time. But yep. Any questions?
Thanks, Corey.
You're welcome.
I guess hearing no questions, then we'll move on to Todd Flanagan. Welcome back to Texas, Todd.
Thank you. I'm Todd Flanagan. I'm a meteorologist with Rainmaker, and I am responsible for the West Texas program in San Angelo, as well as the Trans-Pecos program further west. I just arrived back this past March, but as I actually was here prior to that, from 1998 through 2015, I was the meteorologist for the South Texas program in Pleasanton. So again, I came back this March, so I was not here for 2024, but just a few numbers from last year. For West Texas, we had 24 days of seeding ops, broken down 2 in March, 1 in April, 6 in May, 3 in June, 4 in July, 5 in August, and 3 in September. 65.4 hours of flight time. We used 884 glaciogenic flares and 50 hygroscopic flares. The Trans-Pecos program last year, we had 14 days of operations, broken down, 1 in May, 2 in June, 3 in July, 6 in August, and 2 in September. 23.7 hours of flight time, and flare usage 494 glaciogenic and 51 hygroscopic. So far this year, I'll actually start with the Trans-Pecos. They have been having a very active season of weather out there. It started, I mean, we had one flight in March, but April was incredibly busy for that area. Usually their convective season gets going about May into early June, but April, they were well on their way. So we had a very active April. May, active start and an end, but it was quiet in the middle. Similarly for June. We had no seating in July prior to the big event on July 4th, and then afterwards we were suspended through the end of the month. We reopened for ops again in August, and August was pretty busy too. September so far is quiet at the start, but it's been getting busy so the middle part of the month. So for the Trans-Pecos program, we're up to 54 flights so far this season, totaling 127.41 flight hours. So very active. 31 days with seating operations, plus 9 additional days where we had recon flights, but no seating taking place. Total flare usage so far, 967 glaciogenic and 41 hygroscopic. The Trans-Pecos program runs for another week. The 30th of September will be the last day for the season. For West Texas, again, pretty active there as well, though just a little less compared to Trans-Pecos. So far, we're up to 41 flights for the season, 78.92 flight hours, 28 days of seating operations, plus 3 additional days with recon. Flare usage, 933 glaciogenic and 48 hygroscopic. One thing I forgot to mention, I made a request to Archie to get the analysis for both programs from last season, but as of this meeting, I hadn't gotten a response from him. So I'll reach out to him again to try and get that, and maybe I can send that to you guys once I get that. But that's about all I have to report for now.
Yeah.
Certainly take any questions.
That would be great, Mr. Flanagan, if you would send that as well.
Yep, can do that.
You guys are really busy up there.
Yeah, the Trans-Pecos, I'm familiar with that program to some degree. So I was expecting, well, May, July, some flights, but it just got started in April and they have not slowed down. You get almost a daily occurrence of the upslope flow into the mountains there, the Davis Mountains, the Guadalupe Mountains. So they'll get convection on an almost daily basis right on the edges of the target area. And sometimes that stuff will drift out into the lower elevations, but it's definitely been active out there.
Good.
Thank you very much, Todd. Anybody else have any questions?
Just one quick question.
Yes, sir.
When we have when these flights take place in general, what is there a kind of a standard elevation that these flights take place in?
Oh, good question. Yeah, so as the further west you go in Texas, the average cloud bases tend to go up. So for example, if you're flying down in South Texas, your average cloud basis might be about anywhere from 2,500 to 4,000 feet. You get out to San Angelo, your average cloud bases are like 6,500 to maybe 8,500 feet roundabout. The Trans-Pecos program definitely has the highest average bases, anywhere from 8,000 to 10,000 feet. We try not to go above 12,000 feet if the bases are that high, because really at that point, there's so much air between the cloud base and the surface. A lot of times the rainfall will evaporate before it reaches the ground. So we generally don't see clouds when the bases are that high. Also, it's for the pilots, if they're up that high, we need to start thinking about having supplemental oxygen for them, because that's pretty high altitude to be flying. Yeah.
Thank you.
Mhm.
Any other questions? All right, then we'll move on. Brings us to item G, consideration possible recommendation on applications for new weather modification licenses for the 2026 fiscal year. And I'll turn this over to Chris Huibor to explain these for us. Chris?
Good morning, everybody. I'm Chris with TDLR. Some of you have met me, and I'm hoping to meet a couple of these next meetings so we can meet everybody else. But I wanted to put in your packets, there should be some information on a new weather modification license that we've had. This has not happened in a while, but we are looking for comments, considerations. Originally, the license was supposed to be, or was going to add some new meteorologists, but over time, it looks like we are so no new meteorologists on this one, but it is a new license. So just wanted everybody to take a look at it. One other thing that's happening with this license that has not happened in a while is it is a single licensee that will be operating multiple permits. And in this instance, it is Rainmaker that is going to be fully operating West Texas and Trans-Pecos and is contracting with a few others.
So Chris,
Rainmaker.
you say this has never been done before, but
There have been instances where multiple, to my knowledge, no. It might have been a few years ago, maybe over a decade ago, after some of the conversations with some of the other TDLR individuals that ran this program. But we kind of had to work through some possibilities because there's nothing in the rules that say that it can't happen.
right.
It's just something that hasn't happened before.
That was
But
kind of my understanding as well. Thank you.
yeah. And so what we were looking at, essentially, the reason why, A, it's a new license, so we're going to bring it to you regardless. But B, they are so everybody's still going to have the operational permit. Each organization and program is still going to have their own operational permit. The license will just be held by Rainmaker instead of that organization as well. Still employing the same meteorologist that the organization would. However, now they just work for Rainmaker. Does that make sense?
Yes, sir.
And just a point of clarification, Mr. Chairman, if you will. Man, first of all, I apologize for all the rodeo dust here. But point of information, Rainmaker, you're saying this is a new license the request is for a new license by Rainmaker, which it would incorporate a multitude of operational licenses. And so does Rainmaker currently hold any licenses? Is this and then I have a follow-up question as well.
So I think that was directed towards me.
Yes,
Yes, sir.
But so no, they don't have an existing license. However, they are employing the meteorologists that have been in charge of the previous licenses.
Okay, and so that leads to my follow-up question. The meteorologists that Rainmaker employs are some of the folks that we have heard from previously in this meeting. Is that correct?
That is correct.
Okay. Thank you.
Yep.
Do we have any other questions for Chris or comments or concerns? Hearing none, then I will call for a motion.
You're calling for a motion to recommend approval of the request?
Yes, sir.
So moved.
Second.
All right, Mr. Nance moves and Mr. Page seconds. Do we have any further discussion?
Are we potentially looking at possibly a conflict of interest here. We're being advised by a potential contractor that's seeking licensing, and they have the meteorologists that are advising the board that they are now asking for
That's a good question, Mr. Aber, but we have, I think, traditionally always sought advice from all the operators, the permittees, licensees, and as well as, of course, our staff. And our staff is the unbiased, group that's there. But there's no conflict of interest. We just know where everybody's coming from, if that makes sense.
I guess, but I apologize, Mr. Chairman. I possibly should have stated that a little differently. Has this been looked into to assure that there is none? And it sounds like basically that all of the work has been done on the backside to assure that there are no conflicts of interest here.
Yeah, I will defer to the general counsel if you want to comment on that, or Chris. But I don't see a conflict.
Okay.
Legal Area Assistant General Counsel. I don't see a conflict of interest in having the operations come and give an update at the advisory board meeting. I mean, we do that for informational purposes, so that you can ask them questions, they can provide updates, and yeah, they're not really advising the board so much as they're updating you on their information. It's kind of unlike other regulatory programs because of how they operate. There's only a few of them. They're coming in here and giving their information. And again, it's as the chairman mentioned, it's understood that they don't have this fiduciary relationship with us. They're the licensees. They're giving updates on their activities, and I don't see a conflict of interest in that.
Okay. All right. Thank you, Counselor.
All right, any other discussion? All right. Then I'll call for the roll, please.
James Nance,
Aye.
John Bear Abear,
Aye.
James Sutton Page,
Aye.
Presiding Officer Frank Wright.
You were asking for me. I'm an aye. Sorry. Faded out there.
Motion passes.
All right. Very good. Moving on, we got staff reports. Chris, I'm going to call on you, our program specialist, and let you kind of walk us through.
Yep. So a lot of changes. Some of them do stem from the Rainmaker stepping in and contracting with everybody. But as you can see at the top, we still have 6 operational permits, 5 of which are rain enhancement, 2 of which hail suppression. If we scroll down and look at the licenses for fiscal year 25, you can see West Texas and Trans-Pecos have provisional licenses. Those provisional licenses were granted under the pending license for Rainmaker, which is what we were talking about today. As for the licenses for fiscal year 26, we are in the process of getting those completed. I believe we have everybody's paperwork. I think we're just waiting on payment, and we were waiting on board review for Rainmaker's license. So I should get everybody updated with some of those changes when they occur. A big one that we've had, and I'm sure a lot of you know this already, but a lot of personnel changes since our last meeting. I'm sure everybody was familiar with Adam Foster. Adam Foster ran the program for quite a few years. He had trained me when I had started in 2023. He then accepted a position as the executive director of Texas Alliance of Groundwater Districts, and he moved over there, I want to say at the beginning of 2024. I then stepped in and took over the program. We got Larry Estrada, who I had trained up on the program. However, Larry has also left TDLR, accepted another position. And probably the most unfortunate is earlier this year, we lost David Gunn. David Gunn has retired after 30-something years with the department, which I have accepted his role at the beginning of July. And for a little bit there, it was only me with the water well driller and the weather modification programs. However, we have accepted and started training one of our new hydrologists who is here today, Pecos. So a lot of changes with personnel. Bottom line is I am currently running the program, and we are getting new hydrologists to train on the program so we can be a little bit more efficient. With our current projects, most of the information has stayed the same. The only thing that I'd point out to anybody is Rainmaker is now point of contact for South Texas, Trans-Pecos, and West Texas. And finally, outreach. Trying to go to a little bit more of the national meetings. We are in the process of getting onto the North American Weather Modification Council. We're working to get our membership, as well as trying to attend the fall meeting in late October this year. So that will be a big one, and I'm excited to kind of update everybody once we get some information on that. I think there's some new technologies that might be addressed. It appears to be a good meeting, so I will definitely make sure to update everybody. But that is all I have.
Welcome
Anybody have any
aboard, Chris.
Thank you.
All right. Thank you very much, Chris. That brings us to updates, staff reports from the executive office, and we have our Deputy Executive Director, Steve Bruno. Mr. Bruno, welcome. Thank you.
Thank you, Mr. Chairman. It's wonderful to be with you all today. And let me begin by acknowledging Commissioner Wesson, who's here with us as well. Thank you, Commissioner, for being with us. My name is Steve Bruno, Deputy Executive Director for Licensing and Regulatory Services, and continue the theme that Chris began. We have had a lot of changes in the executive office and changes to TDLR since you all last met. Our executive director, Courtney Arbor, has been on board for about 15 months now. Courtney came to us from over 20 years of service from the Texas Workforce Commission, and she has brought some wonderful things to our executive team. I believe I'm new in my role as Deputy Executive Director since the last time you all met. I previously served as Government Relations Officer, so have had plenty of familiarity with you all and your program. In addition to changes in the executive office, TDLR, once again, it's pretty common every legislative session that we grow, and we received some new programs. You may have heard about them. One of them is residential solar panel installers, the licensing and registration of those folks. As you all are probably aware, we have the electricians program, and you may have seen news reports and other concerns about folks, frankly, being ripped off by people either upselling or overselling the potential of these solar panels. And so the legislature did take action, and that is something that we will begin regulating. We are also have taken over the operations of the Texas Lottery Program and charitable bingo. That's a large lift for us. It's going exceptionally well. You may have heard some stories in the past with some concerns about those programs, and we are very confident that the trust has been restored to the public and those programs are running well. So TDLR grew quite significantly over the last legislative session. It's something that we're very used to, and again, very happy to report that things are going well. let me jump to the end before I provide some more updates. On the legislative front, I'm sure many of you all were paying attention, and I know there'll be an update at the next agenda item, but the quick summary is that there was no legislation passed at all that impacted this program, although some was discussed that I know you're aware of. And again, I know you'll talk about it in a little bit. Nothing passed ultimately. So I think that's good news for the program. I want to share about something very exciting. It's called TDLR Core. TDLR Core is our future licensing system. We're in the middle, we've just begun a 3-year project to transform our licensing systems and bring them into the modern age so that they're more user-friendly, both for you, our licensees, and internally for our staff. This is about a 3-year program, and we're in the middle of right now what's called Wave 1. And we've identified several programs that are going to be the first programs to go into TDLR Core. This is going to put things online when they haven't been available online before, allow you to pay online, make things much more accessible. And I'm very excited to share that weather modification is in that first wave. And it could be as soon as the middle of November that you begin to see and experience some of the changes that eventually all programs will see through TDLR Core. So it's definitely something that we will keep you updated about. And the best way, I'll put in a plug and a reminder for the best way to keep up with information is to subscribe to our email notifications and to share, check our website regularly. And Carmen, are you able to briefly share the screen to show where to sign up, just in case folks don't know, where they can sign up for those email notifications? That's right there, right on our homepage. In the top right, you'll see email updates. You'll simply enter your email address and go through the little prompt to make sure that we know you're a person, and then you'll select the programs that you want to apply for. And obviously, weather modification will be one. And there'll also be TDLR general updates. And I encourage you and anyone else who hasn't signed up to sign up, as those are the best places to get the updates. So some very exciting things happening here for our agency. That summarizes my report, Mr. Chairman, and I'm happy to take any questions or comments.
Thank you, Mr. Breno. Do we have any questions? If we hear none.
All right, very good. Thank you
Thanks
so
for
much.
joining us. Appreciate it. Okay, that brings us then to item I, Discussion Senate Bill 2075 from the 89th session, regular session of 2025. Possible changes regarding advisory board composition, qualification, and terms. Mr. Leary? you're
Yes,
on.
sir. Good morning. Stephen Leary, Assistant General Counsel. I'll be handling items I, J, and K. It's a little bit unusual. I and J are both items I put on the agenda for discussion. They're items that we're in early process of drafting some rules or developing ideas for a rule. And I think that it would be good to get your feedback today on these two topics and then possibly assign a work group so that we can bounce some more ideas off you in a smaller setting and develop a rule package that we can present at a later meeting. So IJ and Kate go together. Item I is having to do with the Senate Bill 2075 and the advisory board bill, and J has to do with our operation report. What I'd like to do, I'll go ahead and discuss item I, and then I'll hear your discussion, and then we'll discuss item J. And for item K, it'll be, if you're going to appoint a work group to further look into those items, that'll be item K. So just to keep everyone up to speed there, the three of those are going to be kind of interrelated. Well, I'll start talking about Senate Bill 2075. So what that was, and I'm going to share it up on the screen. It was a cleanup bill for TDLR that we wrote that was designed to standardize our advisory board. So currently, TDLR has many different advisory boards for the different programs. And that's a byproduct of the fact that over the decades, we've taken on new programs. We've taken on programs from other agencies. The different advisory boards had different names. This particular advisory board was called the Weather Modification Advisory Committee. There's another advisory board that's called a council. So some of them were called boards, some were called committees, some were called councils. And they're very different in terms of how many people were on each advisory board, who was supposed to be on each advisory board. Some of our program advisory boards had ex officio members, some of them didn't. And so Senate Bill 2075 was designed to standardize those advisory boards. And the upshot of that is, and I'm going to share on my screen, I believe I'm sharing the wrong thing. Let's see. Okay. So, do you have 2075 in front of you? On the screen?
Yes, we do, Stephen.
Okay, very good. So the upshot is, as of September 1st, you're now called the advisory board. You're no longer a weather modification advisory committee. It made that change that's a pretty minor change for this program, but it also, in section 6, gives the commission broad rulemaking authority to prescribe these things, to prescribe how many people are on our advisory boards, what their qualifications are, the terms of the advisory board. And it also says that the presiding officer assignment for an advisory board is a 2-year term. For WeatherMod, in our program statute, there isn't any specificity about who's going to be on the board. That's an unusual thing about weather modification. By tradition, we have this sort of diverse group. We have an atmospheric scientist, a rancher, a county judge, farmer, and so forth. And that's all really just tradition. It's always, we have people on here who have been on the board for many years, and we have a tradition of just having this sort of diverse interest. But you'll see, I'll share on our weather modification statute in 301053, it doesn't really specify who's on the board, how many people, or so forth. So because of that, this section 6 of the bill, which is sort of the umbrella provision, it would apply to our program. So the name has been changed to advisory board from advisory committee. This part about the 2-year term for the presiding officer, that would be in effect today. And the rest of this about how we can set by rule, we can set the number of members, the qualifications of the members, and so forth. That's what I want to talk about, whether or not we want to do that and whether we want to look at a rulemaking to do that. So we have a number of ideas about this. I mean, one idea is we could just leave it alone, leave it how it is. For a lot of reasons, it might make sense to actually solidify and rule what the composition of this board is supposed to be going forward. There's been a lot of increased scrutiny of the program, a lot of questions and so forth. Chris and I fielded some questions from the Licensing and Administrative Procedures Committee in the House during one of the bills to deregulate the program. And so there's some questions about the board, who's on the board, and so forth. So one thing we might look at is a rule that would set the number of members and set how many of the members have to be meteorologists or experts, and how many from which flavor, so to speak, or how many farmers, how many ranchers, how many so forth. We can set that by rule. We have some ideas about how to do that. Right now, I believe we have a 5-member board. And there's been discussion from within the agency about switching to a 7-member board. And we don't have to do that, but there's some advantages of having a little bit of a bigger board, is that you get a little bit more diversity of membership. It can make it easier to break into work groups if we're going to break into work groups. It make it easier to get a quorum. So that's one thing that's been talked about, is having 2 meteorologists on the panel instead of 1. We've talked about increasing the size of the board from 5 to 7. We've talked about the 6-year term. So for most of the, for auctioneers, for example, they also made some changes to this bill also affected them. but it affected many of these programs and changed. For most of the programs, the bill made a 6-year staggered term for member. You'll see in here that's a pretty, but not universal. You know, some boards are staying at 7 members, some are doing different things, but usually it's a 6-year term. And the bill says it has to be an odd number of members, has to be at least 3. So 5 works. I mean, 5 meets the criteria. But I want to visit with you about what you would think about a rulemaking to solidify the composition of the board and the qualifications for the members of the board. So I want to open it up to discussion. And if you're interested, or if we want to pursue that as a rulemaking, I think it would make sense to refer that to a work group.
I'll start. I think it's a good idea to increase our number to 7. I think it'd be easier to reach quorum if we could find 7 people that are qualified. I think we ought to move forward with the rulemaking. That's just my take on it. And we kind of line out how many people what qualifications we want: meteorologists, scientists, farmers, ranchers. I guess I'm the unofficial lawyer on the committee, but anyway, however we want to do that, but I think it's all good.
Sounds good to me, Frank.
When you talk about increasing from 5 to 7, if I understand from the counselor, he said it would make it easier to assemble a quorum. I mean, I'm all for, you know, diverse ideas, diverse ideologies, you know, looking at things from different perspectives. A wise man once told me, reasonable people equally informed seldom disagree. So I love that. So getting more and more input to this, I think is an incredible. It's actually a step in the right direction. So I would actually be for the rulemaking as well.
Any other comments? So do we need a formal motion on this, Chris?
What we would need to do is to assign a work group to further develop this idea. I need the presiding officer to appoint a rules work group. So appoint less than a quorum of members. We want 2 members to a work group, and then we'll meet informally with the work group and put together rules, and we'll bring them back later in the process. So that's what I'd ask. We don't need a vote to establish the work group. We just need to find out who's interested in being on a rules work group, and that's part of item K. So if you want, we can do that now, or if you want, we can just move on to item J and then do the work group assignment after item J.
Yeah, let's do the work group after.
Okay.
So we'll open up item J.
Okay.
And K, if you'd like to work them together.
Sure. So item J relates to another issue that's kind of come up in recent months, and it has to do with the operations reporting requirements and how these reports are published. So I'm going to share up the screen. I don't know if I'm sharing this. Let me apologize. I reshare that. I intended to share. You have these in your materials as well. Section 301.117 of the Agriculture Code. Do you have that on your screen?
We see it, Stephen.
Yeah.
Okay, very good. So as you're probably aware, there are certain reports about the activities of cloud seeding that have to get put up on a website, made available to the public. And there's been some concern about how that's done, whether or not we should, at TDLR, handle those reports and furnish them to the public, or whether the operations themselves should post them on their websites. After the flood that happened, there was some open record requests that came in, and people wanted information about where exactly the activities were taking place. And we got a lot of inquiries. And there are some concerns about the operations are posting reports on their website, but they're not very accessible, or there's just concerns about whether or not we at TDLR should warehouse that information and be furnishing it to the public. And there's been a prior rulemaking in 2018. They kind of changed things. They went in the direction of having the operations post the reports on their own website, and there have been some concerns about that. So 301.117, that's the part of our statute that details what kind of records and reports the license holders have to keep. And it specifies in Part B that we're having to require the reports to be submitted to us. And it says in Part C that TDLR is supposed to obtain the records before they're released to the public. And in D, it has that the reports and records in the custody of TDLR have to be made available for public inspection. I'll take a look at the rules that deal with this. We currently have 7931, 7932, and 7933. 7933 is the main rule that deals with this. That's the rule that was changed a number of years ago. Back in 2018, we went from a system where the licensees were sending those reports to TDLR, and then TDLR was releasing them. We went to a system where the operations were posting it on their own website, and we'd review it from their website. But if anyone asked for the reports, that we would direct them to the operations website to get the reports. And that was designed to be more efficient. That's something that an internal auditor had suggested. And as I mentioned, there have been some concerns about that. I just want to briefly review these three rules with you. 7933 is reporting requirements. It details what information has to go in the report. And there's a form that's under federal law from the National Oceanic and Atmospheric Administration that has information that has to go on the report. There's a quarterly report that right now 7933 says you can post it on a publicly available website about the date and time of each operation, the amount of material used, and the observation or data pertaining to the type of weather. So that's one rule. 7932 deals particularly with operations using aircraft and some additional information. That would be most clouds, I think, is by aircraft. We also have hail flares, I understand, or some ground-based operation, but there's particular information that has to be in those reports for aircraft. And 7931 says you have to comply with the federal rules about what has to be on the daily log form, this NOAA form 174B. But 1733, that's a rule we're looking at possibly changing. We're looking at possibly changing the requirement that they put it on a publicly accessible website to either say they have to do that and file it with us, or that we're going to put it on our own website at TDLR. And the reason being, when you go looking for these reports on an operations website, they're kind of hard to find. They're not really in a very consistent place. And we're concerned that under the statute, it's really our duty to maintain those reports and make them available. So it's difficult for us to be in the position of telling people who are asking for those reports that we don't have them, you need to get them from the operation. We feel like that's not a great look, and it arguably doesn't comply with the statute. So we're interested in possibly doing a rulemaking in the interest of transparency, to either post it on our own website or require the operation to post it on their website and also furnish it to us. And I'm open for discussion on that as well. I just wanted to discuss that with you.
Mr. Chairman, Hey, I'm gonna tell you right now, auctioneers, we love to talk. We love to talk. So, uh, council, thank you very much. That was, man, that was a lot of information and certainly, discussions as to some of the reasonings why some of these things are coming up. So I certainly thank you, sir, for being thorough.
Thank
I'm
you.
the guy that asks why. The ultimate question, why? In life, it doesn't matter what the scenario is. The ultimate question is why. But so you discussed, I believe, in the middle section with regard to reporting. What did they do? How much did how much of what type was dropped and when and where and so on and so forth. But if I recall from previous discussion in this session, that a good number of the flights that were done by these operational licensees were also reconnaissance. So are the reconnaissance flights, do they have any reporting as far as, okay, here's what we did, and then later on, subsequently, here's what the reconnaissance flights noticed, and these are the changes. Is that also going to be fall under this reporting recommendation change? And for the record, I am perfectly fine with it being posted in two different spots on the operational website. Perhaps we could have regulation to make it a little more user interface friendly, and again, have it actually on the TDLR. So would that also, the reporting as referenced in the rule, would the reconnaissance reporting also be reflected or be affected by this rule?
That's an excellent question. I don't believe that reconnaissance flights are currently reflected in those reports, but I want to get some guidance from Chris Hoyboyer. Sir, can you help me out with that? Can you confirm it?
Yeah. So the requirement is only when they conduct seeding operations. However, in their annual report, they will, which is due at the end of every fiscal year, we will get that information regardless. So it's not something that we would typically see on those types of reports that we're talking about here. But we are at the opportunity that if that's something that we would want to add to the rule, this would be the time that we can address that.
Okay, so
But regardless, we get the information either way.
Okay, so we get the information in the annual report with, as far as the results from the reconnaissance subsequent to the actual deployment of whatever we're modifying, whatever the modification or the seeding flights, the modification flights, so on. So we get the information from the operation in a timely manner, but I think it's something that's certainly worth looking into, that we could also get the reconnaissance of that in that same timely manner, as opposed to having to wait potentially a whole year to find out, what happened in the first quarter in Q1 of the actual fiscal year. Have to wait to the end of Q4 to figure out how did it do, and what were the results of the flights in Q1. So I think that's certainly something that we should look at.
And Chris, I just want to clarify. So there's a monthly report, a quarterly report, and an annual report. Is that right?
Right. That is correct.
Okay. There's different types of reports.
Okay. And Chris, for further point of information, that monthly, quarterly, and annual, is that a general report, or is that just the operational part, or is that the reconnaissance, the reflection back, or the reconnaissance flights afterwards?
Well, and I think we're getting into like semantics on what the report is or what is required in the report, because this information is also available with the meteorologists throughout, right? They have this information regardless. So it's something that we would need to, because it's not currently required in our monthly report, right? So by the 15th of the following month, you have to have all of the operations that you conducted currently available on your website, right? It sounds like the change that we would be potentially making now would be requiring all flights, including reconnaissance, right? So that would just be like a wording change in the rule that says instead of which ones you actually conducted seeding operations on, we would require a report due by the 15th of the following month for every flight that was taken. Does that make sense?
Yes, sir. Makes complete sense. And thank you very much for the clarification, sir.
Any other board members have any comment?
I think if it's possible, it might be something that we address in the work group. Is that how that would work?
That's what I'm suggesting for this item. We had begun drafting rules to address this, but I think it'd be good to have this discussion in the meeting today and then figure out which board members would be interested in serving on a work group so that we can meet informally between formal meetings and kind of get a good draft together. So that's what we had planned to do today. And yeah.
Sounds good. Well, why don't we move on to item number L? I'm sorry, K, the work group assignments and possible tasks. And Larry, it sounded to me like you're suggesting maybe 2 possible work groups.
We could do 2 work groups, or you could do 1 work group, either way. But yeah, I suggest that we assign these to work groups to further develop the rules. And we have kind of a rough draft going, but we wanted to get your feedback before we presented it. So yeah, if you do that, if you assign it to a work group, then the work group will meet informally and we'll polish up a draft and then we'll present it to the full board at the next board meeting for possible publication in the register. And we'll also the work group will provide us a work group report at the next meeting to kind of summarize what the discussion was and what the work group report. So it could go to 2 separate work groups. Some of our advisory boards have standing work groups, and they commonly work groups meet commonly, between meetings. That really hasn't been a feature of this advisory board. So some of them will have, a rules work group and a standard of practice work group and so forth. It doesn't have to be that formal. You could assign a separate work group to each of these, topics just for this particular task. Or what you might do is if you have members who are interested in rulemaking, you could assign a rules work group and assign both of these tasks to the rules work group. So that's entirely in your discretion as presiding officer. But that's what I would suggest is either create 2 or, poll the members to see who's interested in developing this, and either have 2 separate work groups or have 1 work group.
Gotcha. Okay, thanks. Well, I'll take a little input. I mean, Pat, Mr. Hebert, any of y'all have any suggestions? Any of y'all want to serve on a work group or 2?
Well, I'm actually, as you know, the sitting chairman for the auctioneer advisory group, and I'm actually on a work group there that we're I'm with what's going on and getting into the busy season for auctions. I'm not 100% sure that I actually have the time resource to actually dedicate to this, although I am extremely interested in this. So,
Okay. Well, I mean, and certainly whatever I was going to say, whatever the work group comes up with, that's coming back to all of us for further discussion, modification, what have you.
And I apologize. It's a little rough. I've got a lot of background noise over here. I thought you were asking me if I would be interested in being on the work group, or did I miss here?
I was asking for both. I was asking for comments on whether any of you wanted to be on a work group, and then secondly, whether we thought we should have 1 or 2.
Okay. I apologize if I misheard, Mr. Chairman.
No, you did not.
Okay.
Mr. Page?
You're muted, sir.
You're muted, Sutton.
It did that automatically. I don't know how it did that. No, I'd be happy to serve. And listening, and I don't know if two would be necessary, but two groups, but I would understand if you needed to for particular reasons. But no, I would be happy to serve.
I got you down, Sutton.
What about you, Pat?
No, I don't want to be on a group, but I just, we're talking about reports and groups and all this other stuff. There's not enough public knowledge about what weather modification is all about. And I'd just like to see something come up where more people in Texas understand that the benefits of weather modifications are absolutely out there and they need to know about it. And Texas is drying up and we need more rain. And in weather modification, people don't know what they need to know about weather modification. Doggone it.
James,
You're right.
I would like to comment on that. And the whole time I'm, we're talking about these reports and what's required for these operators to, monthly reports, quarterly, annually. The whole time I'm thinking, as a pilot who was taking this information down every time I lit a flare, whether it be glaciogenic, hygroscopic, whatever, writing down latitude, longitude, temperature, altitude, all those kind of things, where the inflows were, how intense the inflows were. The whole time I'm thinking, to the average person out there that may not know one thing about weather modification, when they're looking at these reports, is it going to make sense to them? I think there's an education, a little bit of educating that would need to be done, and that's a question I would have. Who, if I can ask this, who are the people that are wanting this information? That
Yeah, no, that's
this
a
would be
good
to
question.
Stephen or
Chris?
Frank or Chris.
Yeah, either of y'all have any
I
suggestions
don't.
on that?
I don't know who's filing the open record. But I don't know if I can really disclose that. I can say that there was a strong vocal group that opposes the program in general. Chris and I experienced this when we went to go testify before a legislative committee. There are people who are very suspicious of the program. There was a bill, what did not pass, that was going to criminalize cloud seeding. There was a bill that had to do with solar geoengineering, and this program kind of got mixed up with that in in some of the bill. So there's definitely people who oppose cloud seeding and that would want information because they're suspicious of it. But I don't know if that's everyone who's requesting it. I'm sure there's people who are just curious or they just want more information about what's going on. I don't know who's specifically requesting it, but I know that we got a lot of requests and inquiries after the flood, and there's been,
Sure.
And so that's definitely a part of it.
Well, and I wasn't asking for like names, but like more so, and you just answered it. And I've heard all that stuff. That weather mod is responsible for chemtrails if a chemtrail even exists. I just think there's we were talking about outreach a while ago, and I think there's a lot of educating that could be done. And that may not even be the responsibility of TDLR, but
Well, I would like to jump in and say, we are here as a resource for the public as well, right? We get questions, calls, and we address them to the best of our ability, right?
sure.
For all public, right? So if there are people, we are wanting and looking to address and kind of hopefully fill in some of those knowledge gaps for individuals. And currently we are doing that through our contacts, right? But as for getting more outreach, it's something that we're definitely looking into. But bottom line is we are here as a resource, not only for other agencies, for political situations, but also for the public. So we're here.
Okay.
So here's my take on it. If y'all feel free to pipe up, but it sounds like Pat is not interested in serving on a work group. Mr. Abear's getting into his busy season, understandable. So if that leaves Sutton and me, if that works, we'll be the work group. And then again, at the next meeting of all of us, I would say committee meeting, but now it's a board meeting, next meeting of all of us, then we will discuss any proposals, and we'll get those out to y'all ahead of time too, or staff will. Does that sound like a plan?
Sounds like a plan.
Sounds like a plan that works for me. And I would also like to a degree, mirror the comments of Mr. Sutton here. This, yeah, I've always, I don't know why, I've just always been interested in this. And, you know, this technology has been around for over 50 years. And going in and just being able to try to figure out, you know, what the pros and the cons are, and you know, how to do it, and all of that kind of stuff. It's just absolutely fascinating to me. But I can't begin to count the numbers of people when people ask me, Bear, what all are you involved in? I talk about all the stuff, and then I say, oh, and I'm also a member of the advisory board to the TDLR for weather modification. They get this deer in the headlights look. Like, you know, like my pappy said, they're staring at me like a chicken watching a card trick here, kind of going, what in the world is that? So public education and public outreach I think if they knew more that it existed, then a lot more people would want to know more about it, which I think would kind of just snowball the whole thing. So I appreciate the comments from board member Mr. Sutton there.
Yeah, no, I would agree as well. Let me suggest we put that under item number L, which is at our next meeting. Let's talk about ways of increasing communication and so forth. Some of that's going to be tied into more accessibility of these reports, but reports are just reports. So why don't we discuss that at our next board meeting? Let's try to come up with some ideas. Staff, I encourage you all to do the same thing. For better telling the story, the Weather Modification Association, to the extent y'all are still active in that, I think the meteorologist could also help us with that too. So that brings us, I guess, to item L. Recommendation items for the next board meeting. So we've got that item, we've got the rules that are coming up, and any board members have any other requests of things that we should discuss? If nothing comes to mind today, feel free to email Carmen with suggestions later. Okay, that brings us then to time, date, and location of the next board meeting. I think we're doing all these virtually now, right? So the location's set, but time, Chris, when do you need to have us back?
We don't necessarily have anything too pressing. Really kind of just scheduling around that work group and the rule changes, I think, is the most pressing thing we have. Outside of that, there is the potential or discussions that we've had with people about an additional weather modification license, but I think that won't be until maybe the end of next year. So I think if anything comes up and it's more pressing, I'll obviously reach out and kind of hurry up to try and get one scheduled. But right now we don't have anything pressing.
So should we shoot for something at the end of the year, or the beginning of 2026? And
I think we could.
Go ahead.
I think we could even push it back a little bit, maybe next summer. But again, tentative. If there are things that pop up, I will obviously start the process to start reaching out to people to see if that's something we need sooner. But without anything pressing, I think we can push it back a little bit further.
And then
Chris,
Chris
what
will be
about-
communicating with me and I can poll the board to get that on the schedule.
That sounds good. And Chris, is there any reason we need to meet sooner than next summer on these rules? Should we meet earlier?
I mean, it's completely up to you, right? Because we don't necessarily have anything that would be pressing besides these rules.
And Stephen, is there a reason we need to meet sooner than next summer?
You know, I don't know. I think the issue we're trying to remedy with the rules about the reports, I don't know how much of a problem that's posing right now. I know that there's some concerns about it. I believe the reports are on the operations websites, and that may be something you could work with them in the meantime to make sure that it's accessible. The next meeting, you know, assuming our work group meets and we put together a rule package, and you know, at the next meeting we actually have a vote to propose it in the register. That's really only the first step in the formal process, because then we'd have to have another meeting after that to consider
Right.
the public comment. So I don't know if I'd want to push it off too far. We need time for the work group to meet and kind of refine a rule package, and that might take a few months. So no, we can be flexible on the time frame if there's nothing urgent, but we want to just keep in mind that the rule making does take time.
Okay. Well, here's my suggestion is you all get your heads together, tell us when you think you need us to get together again. And then we'll let Carmen poll us and do that. So if we need to meet in earlier part of next year to work through the rules, we can do that. And if not, we'll just we'll go on whatever schedule you all think we need to do. Okay. I guess there being no further business, we are now adjourned. And Commissioner, thank you for joining us. And I see you had your hand up. Go ahead.
I was going to say, just make sure and thank everyone on the advisory board for their willingness to serve. You know, the pay is astronomical as it is for commissioners, so it's much appreciated of your time. I could be a contact for any advisory board member, you know, to the whole commission, so you don't have to go hunt anybody down. So, Mr. Chairman, if there's anything I can ever do, and I know the commission chair and myself, we're kind of in the South Texas area, and we both laughed and said, hey, if there's ever any extra weight available on any flights, we'd love to go on and kind of see how this operates. I'm a pilot too, like Mr. Page. I don't do weather modifications, but I remember there was something done out of Pleasanton, which isn't too far from where we're at. So if there's ever a possibility, we'd love to see one of these operations in place.
Sounds good. Bria, you might want to reach out to the commissioner or the chairman.
Yes, sir. I'll look into that.
All right. Well, thank you all very much for your time this morning. And,
Thanks, everyone.
Good to see everybody. Let's not make it 2 years again. We'll get a little soon, right? But look forward to seeing everyone soon. And Mr. Sutton, I guess you and I will hear from staff, and y'all send us the materials we need to look at and set up a time for us to get together via Zoom or whatever we need to do, or WebEx.
Sounds good, Frank.
All right. So it is 11:52 p.m. and we are adjourned. Thank you all so much again. Everybody take care. Be safe.
Thank you.
Adios.